First matter to come before the court this morning is, excuse me, these are big here. The State of Ohio versus Joseph Pinckney. Both sides would have 15 minutes to argue. I see the state has waived.
That's
So,
my understanding.
You have the entire 15 minutes to present oral argument. Please don't use the names of any minors or victims, as this oral argument is being recorded and will be posted on the court's YouTube channel. We've read your briefs, we're ready to see when you are.
Thank you, I appreciate that. Obviously, no time for a rebuttal against myself, that would be foolish.
If you really want to argue against yourself, we'll give you time.
That's probably why I'm standing here. I appreciate that. All right, if I may begin.
Please do.
Thank you, very pleased the court, your honors. Does the court request a statement of facts? First of all, I can give just a brief overview. This is essentially an appeal of a murder conviction. Mr. Joseph Pinckney had received a final sentence of life without the possibility of parole. I do want to inform the court that the final offer that was before him before he decided to exercise his trial rights was one of, I think it was about 5 years or less on a reduction to manslaughter. So in terms of the strength and propriety of the case and where it was, he exercised his rights, professing innocence, and that's why we're also here on appeal. The matter essentially involved the shooting death of one individual. The court just requested I not share that name, so I shall not. There was another individual there who ended up being a witness who was shot and injured. There were 3 primary witnesses that the state put on as eyewitnesses to the matter: Tate, Kukla, and Jackson, we will go by. There were various stories among them, various versions of the events. There was a suppression hearing that was held. With that, that is essentially the procedural background. The suppression hearing had been denied. It is one of our issues on appeal here. And there are 4 primary issues that I'd like to address with the court. There were 6 overall, but I think 4 deserve discussion here. The first one is Batson. There was a Batson challenge that was made during jury selection during voir dire. There were 3 African-American potential jurors seated in the veneer among the entire veneer. 2 of them were potentially seated on the petit jury. One of them received a challenge when the state opted to exercise a peremptory challenge to remove that juror. Obviously, the defense attorneys posed an objection under Batson, which then shifted the burden to the state to present a race-neutral rationale for the removal of that juror. What I wanted to discuss here, and what I think it's important for us to talk about, is the difference between the state's appellate response and the actual position that occurred. The rationale that was offered was one where this particular juror had essentially intimated that they thought, on the state's questioning, that it was too early to go to trial without forensic evidence. Within the state's appellate brief, that is the argument that they rest on, that any kind of rationale is enough to overcome a Batson challenge. However, what they left out in their response to our appeal is the fact that that particular juror had been fully rehabilitated, to where on defense's voir dire, they asked, directed specifically to the individuals who had mentioned that without forensic evidence we could not convict. They said, well, if you were presented with 10 witnesses, and if you found that beyond reasonable doubt they presented a story that you believed, could you then convict without forensic evidence? This individual said, sure.
Doesn't that go to the issue of whether they could be removed for cause?
Well, certainly it could, but that was not a challenge. They were removed peremptorily,
Right.
Which is where the Batson challenge came from. So the fact that they were fully rehabilitated kind of nullifies the race-neutral argument that, well, we removed them because they said they could not convict without forensic evidence, when in fact they did. And I really can't underscore that enough. I'm sorry, Judge.
Oh, no, you're fine. I didn't mean to interrupt you. Something that concerned me when I was reading the actual voir dire and the rehabilitation, per se, the defense attorney was very leading in the way it was presented. that, you know, in order to stay on this jury, you will have to say this. That was very concerning. What's
Understood.
your response to that?
Sure, and if I may actually have the quote from the actual voir dire here. Defense counsel had posed, so to the people who said earlier, I can't convict unless I have forensic evidence, I believe this is what you're referring to, Judge. If you understand that it's about quality rather than quantity, and not necessarily the type of evidence, right, juror 3, this particular individual who was struck peremptorily, you might listen to all the evidence and you might be convinced the eyewitnesses are enough. Do you agree? He says, sure. So, to your point, Judge, is it leading, or
Well,
is it...
Keep reading, though.
Yes, and then continues, if you were convinced that that's enough, in order to be a juror on this case, you would have to say, I could vote guilty based on that type of evidence, right? If I was convinced beyond a reasonable doubt that that was enough evidence. Can you do that, sir? So, it was illustrative, certainly, of, of the type of consideration that that juror would have to give to the evidence that was presented. As defense counsel, to have the opportunity to really spell it out for a potential juror, to let them know what the considerations are that they must go through during deliberations, he had the option to say no.
I understand, but usually with that type of situation, the prosecutor or the defense attorney, either one, will ask open-ended question. If you hear this evidence, can you promise to the court that you will uphold your oath, that you will be able to fairly and non-judgmentally, whatever, adhere to this? But this was like, this is what you need to say.
Sure, and I can appreciate that position. What I would also say is that this happened maybe 3/4 of the way through a very lengthy voir dire. So those particular tenets that you're laying out, Your Honor, are things that were certainly already in the consideration set, were already part of the discussion. Certainly this was a peremptory challenge, which means they'd already gone through cause challenges, which means that the entire veneer had already heard a lot of what you're referring to. So I think, to the extent that it was leading, well, certainly it was a very specific question. To the extent that it said, you must say this, individual very easily could have said no, just like they said no when the state asked, could you convict without forensic evidence? I think, similarly, the state's question was very pointed as well. May not have walked the person down that path quite as much, but, again, that opportunity to say yay or nay to that question was absolutely within that person's purview. And based on that, Judge, I believe that it underscores the fact that this was a fallacious race-neutral rationale. The fact that the person did in fact say that it wasn't even acknowledged in the state's response brief here. The state also tried to say that, well, they didn't strike every African-American juror. Well, that's not required. And any prejudice is enough. And that's where we are on that. So I would ask that based on that alone, this be remanded. Secondly, the improper bolstering. Kind of a huge no-no. For a judge to sit on the bench and to bolster an adverse witness's credibility just sours the entire process. I mean, we are here for the jury to be the finders of fact, for the jury to be the one who listen to the arguments and go back and deliberate without any outside influence. We make it a point at every break. Don't talk about this amongst yourselves. Don't seek any outside sources. Don't listen to anybody else. These are the admonitions that we give a jury when they're seated, when they're on break, when they're returned. So for a sitting judge to bolster the credibility of a witness by saying specifically, thank you for coming in here and telling the truth, how can that not have an effect on the jury? Now the state's response to this on appeal is, well, she was talking about thank you for telling us the truth about your prior conviction. But let's truly look at it in context. That is not exactly how it came out. There was a second instance where the judge did ask specifically about about the conviction itself, but in transcript time, that happened about 32 pages later. You know, how long in real time? Well, certainly it was minutes, if not multiple minutes. What had actually been said at the time that the judge made that comment was, the witness, Mr. Kukla, said, you know, I've done 18 and a half years, and this was, I'll take one step back, in context of how was this witness familiar with firearms? What did they know? By the way, that was a key point, because all of this came down to a matter of identifying who the shooter was. So for this witness to say, I saw this person run out and they had a gun in their hand, that goes to truly the core of the state's case against Mr. Pinckney. So to say that this really didn't have anything to do with that, I think is a bit of a stretch. But the testimony that was offered was, you know, I've done 18 and a half years and I learned, you know, but it just seems like every time I bring that situation up, I have a problem, and I ain't trying to have no problems. Judge said, I understand that, sir, and I appreciate and respect the fact that I put you under oath and you told the truth today. So thank you very much. We'll move on. Period. No reference to thanks for telling the truth about your conviction. You know, we understand that sometimes our pasts create problems. Nothing like that. Thank you for telling the truth. If you're seated on that jury, how does that not affect you? To have someone wearing a black robe, such as yourselves, presiding over this entire trial, to say thank you for telling the truth.
What do we do with the fact there's no objection made?
Yeah, so this is a problem with being a trial attorney. You are facing, the simple answer to your question, Judge, I'm not trying to avoid it, is plain error is always on the table. You know, certainly that's something that you could sua sponte, read the transcript here and come up with an argument or an issue that I didn't even present in my brief, and you could rule on that. So that is there. But the fact that no objection was made, I think, speaks to a few things. If the state were here, they would probably argue trial tactics. If I'm standing here as a trial lawyer, it looks really bad to object to a judge on the judge's own statement when you've still got half of a trial to go and you don't expect, you know, some type of adverse ruling against that. We're all human beings. I understand that, you know, the judge is in a very honored position and a position that we would not expect adverse rulings to come from that position just based on personal feelings, but let's be honest, we're all humans. And so to make an objection to something that a judge said that could cause turmoil, I think that speaks directly to a trial attorney's ability to effectually do their job going forward. So that may have been a conscious decision. Unfortunately, that conscious decision may have had an effect of creating an issue for the standard of review for this court. But I would say that a standard of review does exist. And I would argue that making that type of a bold statement of thank you for coming in here and telling the truth certainly rises to plain error. I imagine for anyone sitting on the bench here who's been a trial attorney or a trial judge, I've never been to judge school, but I've got to imagine that that's a pretty strong lesson that is taught. You know, you can't bolster a witness's credibility. Based on that, there were, as I said, three key witnesses. Mr. Kukla was actually the one that did not have other legal entanglements, which brings me to the third point, and I realize I'm short on time, so I will be succinct as I can. The other two witnesses, Tate and Jackson, their identifications of the defendant through Detective Taylor were based solely on a single photograph that was shown to them. The one point that I would like to make to that, and obviously the rest of my argument is in the brief, I would ask that you consider that strongly. The one point that I would like to make to that is that the state seems to say in their reply brief that, well, no photo array was used, therefore it's not necessary to use a photo array. That goes against the tenets of the revised code of 293383. It goes against even the admission that Detective Looney and then later Detective Taylor at trial had made, at suppression and then at trial respectively, that the Akron Police Department has a procedure and a policy in place. They did not follow that procedure and policy. They did not do a show-up. They did not use a blind administrator. They used a single photograph. And they want to rely on the fact that there was some indicia of reliability. However, if you look at the testimony of both Tate and Jackson, you will see that neither of them were able to identify this individual before being shown the picture. Tate gave a generic description of who it was. Jackson said, I didn't look at the shooter, I was worried about the gun, I was hitting the floor, I was scrambling out of there. He only said it was Mr. Pinckney because he had heard someone else say that Red was at the door and he knew Red to be Joseph Pinckney. It wasn't until they were shown the single photograph. So in that case, truly, a photo lineup should have been used and was not. And I realize I'm out of time, so based on that, Your Honors, I would ask that you consider the remainder of the arguments in my brief, and I appreciate your time and questions.
Thank you. Thank you for coming in and presenting oral argument today. The court will take a matter of advisement. We will issue a decision which will be known to all parties to this appeal as well as posted on the Fast Court website.
Thank you very much.